I was born in 1969, and Baylor University was pioneering how to deal with babies who were lactose intolerant. I almost died after I was born because I was vomiting everything that was coming up. So I was part of a study that ultimately came to develop soy alternatives, and the big brand back then was pro-soybean. Throughout my entire life, I've been fighting all sorts of physical things, such as cancer. I'm a man of faith, and I think that God has blessed me with a passion and intelligence to be able to help other people. Consumer law is actually a very big category of different types of cases. I define it as everyday problems for everyday people. When you go buy a car and you have a problem with it, when you have a problem with your landlord, when you have a problem with your mortgage company. Consumer law covers any type of transaction in which a consumer either buys or leases some type of service or product.
We had a contractor that was delivering material to our company. He had stayed over that night and was leaving out for the first thing that morning. The motorcyclist was coming down the road at a high rate of speed. When he pulled out into the street, the motorcyclist went up under the trailer. It was a fatal accident.
The insurance for the trucker paid the motorcyclist's family.
At first, I didn't realize it was that serious because I knew that we didn't have anything to do with it and it wasn't our truck. So, I was just waiting for things to play out. But when they started coming after the parking yard and the trucking company, I started getting concerned.
I was hoping that we wouldn't have to pay for something that wasn't caused by us because it happened on a city street.
Once we got Mr. Sanchez the information and different things, he really went to work with it. He did a really good job, and he assured me they got to do what's best. Yes, I most definitely will recommend this law firm to anyone that I know that really needs someone to represent them.
When clients come through our door, they're feeling nervous, anxious, and used by some of these people that they're purchasing goods or services from. And hopefully, after they leave our office, they'll feel a little bit better about their situation.
Since I was born, I've been a fighter. We are the person that gets in the middle between you and the problem. That problem becomes our problem so that you can get on with your life. Hello, everyone. Welcome to our second Saturday legal webinar sponsored by Sanchez Law Firm. My name is Benjamin Sanchez. I'm here to welcome you to our seminar, which is now accredited by the State Bar of Texas MCLE Department for CLE credit for attorneys throughout the state, in addition to still being a free public webinar for the public. Welcome you today. We're going to be talking about door-to-door sales. We're going to be unveiling the door-to-door salesman scams, what the law is, and what you can do to protect yourself. We're going to be covering on our agenda, we're going to be covering door-to-door sales. Then we're going to be talking about what is not covered under the 3-day right to cancel door-to-door sales law in Texas. We will just talk about the specifics of the 3-day right to counsel. We'll talk about how you can cancel a door-to-door sales, and then just some general tips about avoiding scams and rip-offs when it comes to door-to-door sales. So let's talk about what a door-to-door sales actually is. The law says that first of all, the primary thing is that the sale cannot take place at the seller's place of business. In the Texas Business and Commerce Code, they use the word merchant. They define what a merchant is, but for our purposes, we're just going to be saying seller. So it cannot be done at the seller's primary place of business. What you may not know, and what this slide will show, is that it's not limited to sales at your home. Door-to-door sales really means any sale that's conducted away from the seller's primary place of business. So let's say you go to an event like a bridal show or a gun show or something like that, and it's just an event. Door-to-door sales law actually covers those sales. In addition, if you go to a flea market and you buy something at a flea market, actually door-to-door sales covers that. So we generally think of door-to-door sales as someone coming to your home to make that purchase, but that is actually not the case. That is the primary use of door-to-door sales, but you should be aware. Now, obviously, if you go to a flea market, most people are not going to be handing you, a receipt that has the language that we're going to talk about with your notice of cancellation. It's important for you to understand what your rights are. But it's important for you to really know that a door-to-door sales is not specifically just someone coming up to your door and asking you to buy something. Now, the sales can take place at any place other than the seller's place of business. Furthermore, the agreement to purchase also must take place at any other place than the seller's business. So, for example, if you have someone that comes to your home, tries to get you to sell something, sells you something, but then later you don't sign anything that day, and then later you actually go to the seller's place of business to actually sign the agreement, then this law does not cover you. So the entire transaction has to take place away from the seller's place of business. It is not something where you can, do part of it here and part of it there. So it's just all the sales process and the agreement all must take place away from the seller's place of business. Furthermore, the goods or services that you may purchase, they have to be valued at more than $25. So if you buy something really cheap, it's $25 or less, then even if you meet the other requirements, this is not going to cover you. Or the real estate that you purchase has to be more than $100. So obviously in this day and age, most likely you're not going to find real estate at $100. But the law is clear that real estate purchases in sales, the value of that real estate must be more than $100. So what does that mean? Does that mean that you could potentially have real estate given to you, or you're with a family or friend and you just do a real cheap swap or something like that? That won't be covered. So the purchase price of a real estate must be more than $100, and the purchase price of the goods or services must be more than $25. So now that we have a idea of what door-to-door sales are, we'll go to what is not covered under the law. And for you attorneys out there, we're basically covering the law that is the Texas Home Solicitation Act. It is in chapter 601 of the Texas Business and Commerce Code. So those are the specific title is cancellation of certain consumer transactions. And these are the transactions that we're talking about. So what is not covered under this Texas law? Well, the sale of insurance or farm equipment is not covered under this law. A sale where the purchaser, if you're the buyer, is represented by an attorney, even if it takes place away from the seller's business, is not covered under this law. If you're dealing with real estate and you have a real estate broker or real estate brokers involved, then this law does not apply to you. If the purchase or the sale occurs as a result of prior negotiations at that place of business, at the seller's place of business, then it's not covered. So, for example, let's say you go to, I don't know, let's say an appliance store. You see a nice refrigerator or a washing dryer that you like, but then you don't buy it there. And then later, someone offers to come to your home, a salesman offers to come to your home to get you to sign the paperwork to kind of complete the deal. That will not be covered because you first went to and had some negotiations with the seller at the place of business. It was only concluded at your home. And so, again, we talked about earlier, you have to have both parts, both the sale and the agreement, happen away from the seller's place of business. Now, if um, you had, it could be different locations. And then we talk about that. You could have one home where the sales presentation takes place and another home where the agreement takes place. And um, in that particular situation, it's still away from the seller's place of business. That home, again, does not have to be your home. So another thing that I think is people like to throw these parties where they want to sell Tupperware or makeup or whatever. But let's say you go to someone's house, you're part of that party, you see something, and then you don't buy anything, but then later that salesperson then goes to your house for a one-on-one meeting after this group presentation at someone else's house. That is still covered because, again, the one-on-one presentation happened away from the seller's place of business, and then the agreement to buy happened at your home. What we cannot do, though, is if you have, for example, a salesperson who has a home-based business, and let's say they're selling Mary Kay or Tupperware or something, and their home is their place of business because they're a home-based business. Be aware of that. So what I'm not talking about is you going to someone's home who lives there, throws a party, and then they go to your home to finalize a deal. Well, technically, you are at that seller's place of business because they have a home-based business at the time that the sales pitch was done. So in that situation, what I'm talking about is you have a party, you all invite some salesman to come in and give you all a presentation, and then later that salesman then individually goes to the attendees' homes to complete the individual deals. Okay. The other thing that's not covered is sales made entirely by mail or telephone with no other contact. And why do we say that? Because why does the law say that? There's a different kind of pressure, face to face, in person. So with a telephone call, you can always hang up on someone. You can always have someone else listening in. That pressure of having to buy something over the phone is not as high as having that pressure in person. And again, that pressure is even less when it's all done through mail. So, but if you have someone who mails you something, and then you have a telephone call, and then you have an in-sales presentation, in-home presentation, that could be covered. So maybe someone introduces themselves introduces themselves to you through a mailer, but then you call them and they set up an in-home meeting with you to have a presentation. That is covered. Now we know what is covered and what is not covered. I think that this is just these two slides and information alone. It gives people a lot of insight because most people think of door-to-door sales as anything from someone's to you at your house. And you can see by now that it's much broader than that. So now we go to what is the primary purpose of this law, which is the 3-day right to cancel. The first thing you should understand is that 3 days is not 3 calendar days. So there may be a situation, for example, that a 3-day period could actually turn into a 5-day period if you have weekends involved. So if someone sells you something on a Friday, the next business day, the next day is considered a Monday because that's the next business day. And then Tuesday and Wednesday, so you actually have up until Wednesday on a Friday sale, and you just back it up. So on a Monday, you have 3 business days. On a Tuesday, you got 3 business days. And then on Wednesday, Thursday, Friday, you have to account for the weekend days, however many there are. What do you have to do? It's by midnight of that 3rd business day. Now, most of the time, we're going to talk about the process of getting the cancellation done will probably need to happen during the day because we're talking about mailing it back. But technically, the law says that you have until midnight. And that may be because maybe the seller gives you different ways to send them the notice of cancellation that we'll talk about later. So if you have a right to fax it or you have a right to email it, or, not a right, but if you have the opportunity, the law says you should mail it, right? But sometimes the seller can give you additional rights. And so if they give you that, then you should, you could do it potentially by midnight of the 3rd day. Now, the seller is required to give you that 3-day, your notice that you have a 3-day right to cancellation. That notice has to be given either in the contract that you sign or a receipt for the purchase. The 3-day notice must contain the date of the sale, remember, so we can figure out those 3 days, the name and address of the seller, again, also referred to as merchant in the law, and a statement that you have the right to cancel your contract, including an address for where to send that notice of cancellation. The contract, so there's a notice of cancellation is very important because that's what gives you the law. We do a lot of, here in Sanchez Law Firm, we do a lot of consumer law. We have clients that have been victims of door-to-door sales. A lot of times they get no paperwork, or they sign something electronically and then they don't get that electronic document. Someone will say, oh, well, we're going to email it to you or whatever, and they never get it. So it's important that you get these documents because it's important for the seller to give you these documents under the law so that you're protected. A lot of times, especially in Texas, we have Spanish language or other language sales presentations. And then what we see is that the door-to-door salesperson gives the documents, the contract, the receipt, the notice of cancellation, all in English, when the person clearly was speaking another language during the sales process. So the law says that to the extent that you are speaking a non-English language in the sales presentation, that the documents that you get also have to be in that same language. So you need to make sure that you get a Spanish language contract, receipt, and notice of cancellation, right? Cancellation statement. Very important. We've seen a lot of times that our Spanish-speaking clients who are victims of door-to-door sales, they get either no documents or they get English documents that they clearly don't understand at the time that they sign them. So it's very important, this 3-day right to cancellation. Now, what does the statement of right to cancel? The law gives you specific requirements of what that statement on a right to cancel must include. The statement, as you'll see, it has to be close to the signature line of the contract, or it has to be on the front page of a receipt. What we see sometimes, for example, is you are given a multi-page contract, and if that statement exists at all, sometimes it exists somewhere other than close to the signature line. Why is this important? Because the law wants to protect you so that when you sign, you see the statement close to it, so that you understand what that is. Many times we've seen multi-page contracts, especially in solar panel sales, where there's all sorts of different terms and conditions, and that the statement really needs to be close to the signature so you have the right to cancel. Again, if you have a receipt, because you're not required to have a contract. If you just have a receipt for the purchase of goods or services, then this statement must be on the first page of the receipt. The statement itself must be a minimum of 10-point font in boldface. Now, I will tell you that 10-point font is actually not very large, especially for people who have bad eyesight or they're elderly, their eyes are failing them. If I had my druthers, I would want to see either 14 or 16-point font for this statement. So I think that the size of this was a compromise between the legislature and the people who were debating this law, that there had to be some language, but they didn't want it necessarily to be overpowering. So to me, even though I like the fact that the law requires the statement, I don't like the fact that the point size is 10 points. I mean, 10 point is what you see in footers. 10 point is what you see sometimes in, the fine print, as we like to say in the legal industry. But it has to be boldface at a minimum of 10-point font. And then the law says it has to be substantially this statement. So the statement that I put on the screen, this is what is pulled directly from the statute. But the statute says it doesn't have to be exactly this. It just says substantially the following form. And what does that form say? It says you, the buyer, may cancel this transaction at any time prior to midnight of the third business day after the date of this transaction. See the attached notice of cancellation form for an explanation of this right. Now, why is that statement important? One, it gives you your right. It tells you about your right to cancel. It tells you that you have 3 business days, not calendar days. It tells you that you have until midnight of that third business day to cancel. But it also tells you that you should be expecting another document. So if the receipt or the contract gives you this statement, but you actually don't get the notice of cancellation form that is referenced in this statement, then your documents are not complete. The law is designed so that you don't have to try to create your own notice of cancellation, try to figure out what language you should use, right? That notice of cancellation form should be given to you along with the other documents. So again, when you see this statement, make sure that you actually have another document that contains the notice of cancellation form, because that form itself will be what you sign and you return to cancel the contract. So again, 10-point boldface this language, first page of receipt or close to the signature line of the document. Now, I know that I could have been going a little faster on all this, and we'll kind of do some review at the end. But I want to make sure that you understand the law here. Now, once you have your purchase, let me just back up real quick. The date is the date that you actually sign the contract, or the date that you sign the offer to purchase. So you make an offer to purchase, you sign that, we sign the contract. That is the date. So if you have multiple home visits, then it's only when you actually sign something that starts the 3-day trigger on this 3-day right to cancel. You could have multiple visits. You could even have a visit where you sign something acknowledging that you received the sales package, that you received the sales presentation, that you received flyers or whatever. But until you actually sign the agreement to purchase or an offer to purchase, you really haven't signed anything binding yourself to the purchase. So the idea is that once you bind yourself to the purchase in writing, that is what triggers the 3-day rule. So now we're on canceling the actual transaction. So the notice of cancellation form that you get, again, is going to be filled out. It should be filled out. It should be easy enough for you to know what to put in there and then to send it back to them. In the form, you must sign and date the notice of cancellation form and mail it to the address on the form. Again, I've seen some people say that you can email it to this address or you can fax it to this address. Even if you can do those other things, I highly suggest that you mail that form. And guess what? The mail, you should spend a few extra dollars to mail that by certified mail so that you get some sort of tracking number. You could also do it by overnight mail. The law doesn't say what form the mail should be, but you need something with a tracking number so that you can track that they get it. A certified mail is good because you also get a signature back. But some people will do, for example, a priority mail, or they're doing overnight mail without a signature, so they prove that it was sent and that was delivered. Again, the law says that you must mail that form after you sign and date it to the address that's on the form. I would certainly, obviously, copy the form before you mail it. I would make sure you have all the proof that you did mail it, including your certified mail label. In this day and age, when we deal with electronic documents so much, a lot of people don't really keep original documents. I would say that even though you could potentially scan your proof of mailing and all that, that I would definitely keep the originals, have some sort of important file folder for yourself, keep it in some safe place, and keep those original documents, even if you scan them for your own electronic records, because what you don't need is someone stating that you somehow made up a form. Now that's going to be hard to do, again, when you certify mail it, because the United States Postal Service, obviously will have those tracking numbers. So those are official government issued tracking numbers, but you never know what people can say. The other thing is that there is no specific time as to how long that mail has to take to get to the seller. It's just that you have to put it in the mail. So have a postmark that's no later than the 3rd business day, but you have to put it in the mail by then. The reason I say this is because a lot of times what we've been seeing here at Sanchez Law Firm is the U.S. Postal Service is severely understaffed. They have a lot of problems these days. We see mail, whether it's our demand letters or other things being delivered that are in transit. They're stuck in transit for a long time, or they go to different locations. And so it may be a while before the recipient actually gets the mail. So the law just says that as long as you can prove that you did put it in the mail by the 3rd business day, that you're okay. We generally like to do things by certified mail and regular mail, so that if someone says that, like, refuses to sign the form and never picks up the certified mail, that they still have this other copy that they get. As long as that mail doesn't come back, then it's presumed that they received it. It was a valid address. So even if they don't sign for something, or they try to say, well, I never got it, so I didn't know that there was a cancellation. Well, again, you got the regular notice, the regular mail notice, and you just refused to sign the certified mail. So that's what I would suggest you doing. Now, it's important after the cancellation, and this is where it gets a little bit fuzzy. So, but the salesman has some duties here. The question is when does that duty take place? Obviously, the law can't force the salesman to do something if they never received the notice. So this is where it's important to say, okay, it's not the timeline we're talking about here starts when the salesman receives the cancellation, not when you mail it. But after you cancel the sale, then the salesperson has 10 days to refund your money, to cancel and return any kind of financial note or instrument, security document for whatever you signed for that purchase, and return any trade-ins that you may have done as a result of that purchase. So you think about that. Let's say your mail gets stuck in the mail for a month. They finally get it. Once they get it, they have in essence 2 weeks, but specifically they have 10 business days to do this. If you are a seller who's engaged in this business, what does that mean? That means that you need to keep any trade-in items for that period of time that you'd be required to return this. So and there's a little bit of a tricky situation when something gets lost in the mail ultra long, but I would suggest that sellers end up keeping those trade-in items for at least a couple months just to make sure that nothing got lost in the mail after that notice of cancellation was sent by the consumer. What are we talking about here in terms of trade-ins? Well, you can buy a car at a door-to-door sales. You can buy all sorts of things that you end up trading in. So, I know it sounds kind of weird, but whatever you give to the seller as part of the purchase as a trade-in, they have to keep that and then be able to give it back to you within 10 days if you cancel. Now, in addition to what I just said in terms of returning the trade-in, returning any kind of original financing agreement or note, and refunding any money you paid, the salesperson must demand possession of goods or services or the title to the real property within a reasonable time after cancellation, or those goods or services or property will be considered abandoned, and therefore you as the consumer can keep them. It's important to note that the seller cannot force you to go someplace to return any items. So if they make a demand for possession of something that was given to you in the sale, then they are allowed to they're not allowed to ask you to go to a car lot or some other place to deliver it. So if you have for example, if you have a seller who has a place of business and but they sell it to you at home, and then you cancel, and then they demand whatever they sold you back, they can't say, come to our business, bring it back to us. Nope. You have the right to stay at your home and have them bring it there. It's important. Most people don't know about that abandonment rule. So again, the law does say that 20 days is presumed to be a reasonable time, but there is no exact requirement. So again, the law says reasonable time, and then in another place in the law it says for that quote reasonable time, 20 days is presumed to be a reasonable time. But there may be circumstances that show that 20 days is not reasonable time. If you have natural disasters, if you have, let's say COVID, here in Houston, we have hurricanes that shut down things. You've got tornadoes that shut down things. It's fact specific, but generally speaking, you have 20 days. The seller has 20 days to demand their goods or services or deed documents, title documents to real estate back, or it's considered abandoned, and you get to keep it. And you're not punished for it, and you still get the cancellation. So that is a very kind of overview of what the law is, what door-to-door sales are, And especially for you consumers out there, I wanted to give you some tips to avoid scams and ripoffs. One of the important things is the law does not actually require, the state law does not actually require um, door-to-door salespeople to get licenses for door-to-door sales. Now, whatever they're selling may require a license, but there is no license for door-to-door sales, so there's no particular identification that is going to be given to door-to-door sales to do their job. In fact, most door-to-door salesmen are, they're just that. They're just salesmen. Whether they have a degree or not, whether they have a license or not, they're just people like you and me. They're just door-to-door salespeople. So I would I would urge you to ask for identification. Some people will go to the door and they will wear a lanyard with something that looks official, right? But what is that really? It's just something that they could have made up or their company could have made it. It could be an official looking badge, or it could be, some sort of employee ID or something. But in this day and age, we all know that you can create documents and then use a printer to print those out and then make them look like that they're serious and they should be taken seriously. But that name may not be that person's name. That company may not be that person's company. A lot of time what we see, especially like in the solar panel industry, is that the solar panel company who's, quote, the solar company who's selling is not the actual seller who's selling. They hire other people to do door-to-door sales, either on an independent contract basis, one-on-one, or they hire a company who then has their people go out and sell to you. So the person who's selling to you is not even employed by the solar panel company. So I would certainly ask for identification. When I say identification, I mean like state issued government identification. So you know exactly who the person is. Because if you come to me or some other attorney later and saying, John Smith was the one that sold it to me, but John Smith was just an alias because that door-to-door salesman didn't want to give you his real name. And we asked some company, hey, who's John Smith? On their records, it's the real person. And that real person, may be Mark Twain, right? So the person comes up to you, their name is Mark Twain, but for alias purposes, they're John Smith. You think they're John Smith, you never realize that they're not. So it's important to ask for those company ID and badges. Now, there are some cities in Texas, and I think Irving, Texas, in between Dallas and Fort Worth is one of them, but there are some cities who actually do require door-to-door salespeople to register with the city and get some sort of issued license to be able to do that. That is on a local basis. That is not required by the door-to-door Texas law, the Texas Home Solicitation Act. The other thing you should do is you should ask for and check the physical address and references for the person who's doing this. If they are a legitimate company and they are proud of their products, then they would be willing to give you references of other people who bought it. Okay, you should really check those out. Now, make sure that those references are real, because sometimes they give you names and phone numbers, and when you call them, you think that you're talking to someone who's purchased their product, but all you're doing is you're talking to someone who's pretending to be a customer, just someone else, whether they're friends or family or another, door-to-door salesperson or whatever. Well, we once had a case where our client was engaged in a solar panel transaction, and in the middle of the door-to-door sales presentation in the home, the salesman said, well, I'm going to call our engineer who's going to explain, more of the physics and the science behind solar panels, so you can know that what we're selling works. But when we ended up suing that company, we found out that person who was, quote, an engineer was never an engineer. Okay. And the company couldn't even give us an address for the person who was supposed to be the quote professional engineer who explained the physics and science of solar panels to our client. So not everything checks out. You got to do your due diligence. Again, the physical address is important because you want to know that there's some place you can actually um, send that notice of cancellation to. You want to know if there's a brick and mortar store or if it's an online store. You kind of want to know that. Where can you check? So most most business entities that are partnerships or limited liability companies or corporations, they have to file, or they're mandated to file with the Texas Secretary of State, and they have to have a registered agent with the Texas Secretary of State. Not all companies do that. Some people just avoid that entirely, but that is one place to check, is the Texas Secretary of State, to see if it's a legitimate business, if they say they're an LLC or some sort of corporate form. Then you also have county clerks. So a lot of people do they do business as something else. So I could be Benjamin Sanchez doing business at Sanchez Law Firm from a personal perspective. If I do that correctly, I would go to here locally, Harris County, in the Harris County Clerk's office, and fill out a DBA form and then file that. And then I would be officially registered as a doing business as with the county clerk. Now, I'm not that because we have a corporate form, but people who don't want to create, these corporate forms, they can file something with the county clerk as doing business as. So they're an assumed name. They're just John Smith doing business as Smith Roofing Services. Okay. And then the other place you should check, obviously, is the Better Business Bureau. So if there are complaints, you want to read about those complaints, see what kind of grades that they have with the Better Business Bureau. Are they even registered with the Better Business Bureau? If they're not registered, maybe you want to think twice. Another thing is, feel free to say no or to ask for more time to decide. Any legitimate business doesn't need to pressure you. You don't have to be pushed or pressured into signing something if you feel kind of off about it. In fact, I heard one of my mottos that I tell my clients is, don't ever buy something on the first sales call. And that applies to in-person or phone solicitations or whatever. You can get the information the first time, but give yourself your own cooling off period before the law allows you to have one, before you kind of engage in deciding whether to do that. So don't be pushed or pressured. Feel free to say, hey, I thank you for your presentation. Come back tomorrow or come back next week. Set up a time. If they really are a legitimate business, they will honor that request. If they say, no, this is a one-time deal, you need to do it now, we're not coming back again, then it's their loss. Okay? So you can either say no up front, you can say come back, but be free to give yourself that authority to do that for yourself. The other thing is you want to ask for any documents that you sign, even if those documents are electronic. A lot of times these days, people are going around with iPads and other kind of electronic tablets, and everything that you see is electronic. They don't carry paper with them. And so they'll give you a sales presentation on their computer. They'll ask you to sign documents on the computer. And, it's all done electronically in your home. But then, they'll tell you, well, we'll email you the documents. Okay, we'll email you the documents. You let them leave and you didn't get anything you signed. Now you're stuck and you don't know what you signed. You don't know if they're going to change the documents that you signed or whatever. If they are refused to give you documents, make sure you check that up front. So you want to know up front that they're going to be able to give you these documents. If they say they're going to email you these documents, then you need to make sure that they email them to you right then and there. They have a computer, or they have an iPad or a laptop, they should be able to email you exactly what you signed right then and there. Even if they say, well, we need a counter signature from someone, I'm just a sales guy. We need our manager to countersign this document. So after he signs it, we'll give it to you. No, you get to have the documents that you sign right then and there. What are the most important documents, right? Those are the contract or the receipt, whichever you sign, whichever you do, because you don't have to have a contract. You gotta have something showing that you purchased it. So either a contract or a receipt. And then you have to have that notice of cancellation form. If for some reason, worst comes to worst, they will not give you anything, then you should insist on taking photos, snapshots with your phone of the actual screen. Okay, I know that's less than ideal, but you got to find some way to protect yourself. Okay, so you got to be able to show that you signed something. So if they're not willing to give you something right then and there, you want to be able to take pictures of what you're signing so that later, if they say, well, no, you didn't sign it, or you signed this other document, they could take your signature, which we've seen, unfortunately, in electronic documents. We've seen signatures taken from one document and manipulated onto another document. So just be aware of that. Don't believe the buy now or else. Okay, even if it's a natural disaster and people are talking about roofs and things like that, just there's nothing in this world that really requires a buy now or else. If there's language like that used, don't trust that person. Even if you like the product, don't buy the product from that person because they obviously are not above board if they're going to say buy now or else. Just don't believe that. Don't trust it. Again, natural disasters we have hailstorms in Texas. We have tornadoes. We have wind gusts. We have hurricanes. All sorts of things that happen. And quite frankly, there are a lot of door-to-door salespeople that go through neighborhoods after a natural disaster, just knock on doors and try to get everybody to sign up with them. And you're vulnerable at that time. Someone may have been hurt, your property's been damaged, you're not thinking clearly because you don't know what's going to happen next. You got to be very careful of people who come through there. I know that you want to get your roof patched up, you want to get your wall, the hole in your wall, or your car fixed, or whatever the case may be. But be clear about it. Okay, you got to slow down. Just take precautions. If you kind of do the things that we're talking about, and you slow down and you take those precautions, you'll be in a much clearer state of mind by the time you actually sign. Especially if you don't do it all in the same day, the same transaction. Do the sales presentation one day if you must, but then make sure they come back another day to give you some time to really, really think about it. Figure out, what it is that they're selling you. Is it something you just want? Is it something that you really need? Okay. Quite frankly, I just don't like door-to-door sales at all. But you got to really figure it out. If it's something you want, maybe you shouldn't do it. Maybe you should find another way to get what you want through, a good method. Obviously, Amazon these days is online. There's still brick and mortar stores. There's all sorts of ways to get things to that are going to be legitimate and don't have to involve the high stakes and pressure of door-to-door sales. Okay, so just figure out. Is it something you want? Is it something you need? If it's something you need, you still need to take some precautions there. Also, don't do it alone. So if you're home alone, someone comes to your door and they knock on your door and they want to sell you something, it'd be best, quite frankly, that you get someone to be with you so that they can not only be a witness, but they can be your buffer. They can be the person to kind of talk to you, as to whether or not this is a good deal. They can ask questions that maybe you haven't thought of. Remember, the more minds you have together, the collective, that's why we have a jury, the more minds you have together, the better decisions can be made. Make sure it's someone who is actually going to, that you trust to help make that decision, to give you advice or guidance. it's weird. We did have, I've seen cases where a couple is at home and there's a kitchen table and the salesman is presenting the product. And then the husband, who's worked all day, because this is like a late afternoon sales, works all day, ends up falling asleep during the presentation. And the wife does not stop the presentation. The wife does not wake up her husband before. The wife just continues and then signs everything. And then, the husband is woken up as the salesman is leaving. And then they realize later, like, oh, well, if the husband had stayed awake, of course, hindsight's 2020, so there's not something they can really do about that now. Um, but you got to have someone who's going to be engaged with you in the sales process, not someone who's just in another room, for security or whatever. You want to have someone who can really be your buffer and make sure that it's something that you truly want to do. I really don't think you should be doing these at all, but if you must, then at least have someone with you. We have any questions? Okay.
Farmers market fall under this category for door-to-door sales?
So the question is does a farmer's market fall under this category for the door-to-door sales? It depends upon whether or not the seller, if that is their regular place of business. So if you have someone who has a booth stalled at a flea market and that is their regular place of business, then it would not fall under this, right? So what we're talking about is temporary setups or an event or things like that. We're not talking about people who have regular stalls at a flea market, and that kind of stuff. Now, if you have a regular place of business, someone who owns a regular place of business, and then temporarily set up a stall at a farmer's market, that it's temporary. It's not just like another location of their business. Then that would be fall under this. But if this stall is sort of another location of their business because it's a regular thing that they do all the time, then this would not apply. It's important that the place where you buy this is not a regular place of business for the seller. Another question?
Regarding 3-day notice, while weekends would not count towards the 3-day notice, if a federal holiday is in that 3-day window, would it count as a day as well, or is it exempt towards 3 days?
So the question is in the 3-day notice, if one of those days is a federal holiday, does that count? And really, this really is about the last day, right? So you can't, on federal holidays, the post office is closed, right? So there's no way of having a postmark on that day. I certainly would take that into account when you're thinking about your cancellation. So if, for example, you buy something on a Wednesday, and then the following Monday is a holiday, and that's the third business day, you would be wise to try to get it out in the mail no later than that Saturday if your local post office is open on Friday. I think that the legal answer is that you will get that extra day. Man, I wouldn't want to risk it. But I think that the correct legal answer is they can't hold that against you. I will say that the law itself, the Texas Business Code, doesn't talk about. I have the code here. Just let me make sure. So the law just talks about 3 business days. It doesn't state that it doesn't refer to holidays. And specifically for your attorneys out there, Section 601.051 of the Texas Business and Commerce Code states that a consumer may cancel a consumer transaction not later than midnight of the 3rd business day after the date the consumer signs an agreement or offer to purchase. So there is no additional language regarding holidays. So that's why I would just be careful. I think you can make the argument that there's no way to put something in the mail on a federal holiday. I wouldn't want to take the risk. And again, we're talking about the service, the postal service. So let's say you have a state holiday in Texas. We have state holidays that are not federal holidays. I don't think that gets you there because the post office would still be open on that 3rd day. So we're just talking about, federal holidays in which the postal service is closed. So therefore you can't get a postmark on that document, that notice of cancellation form. Anything else? So guys, I want to thank you for joining us. Just kind of want to go over a few things with you. I mean, obviously you can call our office. We do a lot of consumer law here, a lot of door-to-door sales, including solar panels. We are growing our solar panel litigation practice as well. If you have any questions, you can call that number on the screen, 713-780-7745. Also, you can email us at info@sanchezlawfirm.com. We have a website that has information, videos, blogs, all sorts of things. And I want to kind of give you a preview of what's coming up in terms of our next second Saturday series. On April 13th, the second Saturday of April, we'll be going over Residential Construction Liability Act claims, otherwise known as RCLA. But these are claims where there is some construction done or home repair done on a home, and what you, the consumer, what rights you have under that law to make a claim. We'll go into a deep dive of what that is, including what rights the contractor has from you in terms of right to inspect, right to make offers of settlement. So we'll do a deep dive on April 13th about residential construction liability claims. We look forward to having you there. The next second Saturday series beyond that will actually be on my birthday, May 11th. The second Saturday of May will be my birthday. I will give a special presentation on lemon law and defective car claims. Now, it's going to be important that you understand that lemon law is referred to new cars in Texas, and they're totally separate from used car sales. We have talked about used car sales in the past, but this is specifically on defective cars that fall under lemon law in Texas and what to do about those. So the second Saturday of May, May 11th, we will talk about lemon law claims on that day. In June, the second Saturday of June, June 8th, we will talk about car repair claims. So whenever you bring your car to a mechanic and you have some sort of beef or gripe with the mechanic or the mechanic with you, there are certain rights the mechanic has to potentially keep your car, to charge storage. There's certain rights that you have, and we'll talk about car repair claims in June. And then the last one I want to tell you about is upcoming on July 13th. We will be talking about solar panel claims. Again, solar panels are getting bigger and bigger. We see news presentations and newscasts all the time on people getting ripped off by solar panel claims or solar panel companies. That whole industry has a lot of things going on. There are a lot of different pieces to the puzzle. There's not really great law on it per se. There's no law that really deals specifically with solar panels, but we will go over, for example, how the 3-day right to cancel applies to that. We're talking about the financing companies. We're talking about the door-to-door salesman versus the solar panel company. So we'll get into the law and to the practical aspects of solar panel claims in July. So we look forward to seeing you there. And then the last thing I want to bring up to you is that, well, actually, one more thing. So, for those attorneys who are attending, we do have a CLE number, and that MCLE number is on the screen, but it is 174-22-9979. Again, that is 174-22-9979. And in case you don't know, this presentation, as with all of our second Saturday series coming up, and hopefully we'll get credit for the ones going back, are going to have 1 hour of CLE, most of the time without ethics, but we'll see if we can get some ethics credit for some of our CLEs going forward. But if you get 1 hour free CLE ethics every month by watching the second Saturday, and that'll give you 12 hours of CLE every year just by watching us every second Saturday. And then I think I just want to close by saying that we are going to be having a new podcast with Sanchez Law Firm. It's called Legal Grounds. It is something that is a iteration of what we used to do, where we used to have live broadcasts, and we hope that you will join us. That podcast will be coming soon. We'll have one this month. It'll be every month, and we'll figure out a specific release date of each month to have it on. But we hope that you will subscribe to Legal Grounds on all the major platforms coming soon, where Alexis Gutierrez, my marketing director, and I sit down and talk about the law, talk about legal events, talk about law in the news and other things. So we look forward to presenting that to you and hope that you have a great weekend. Have a good day. Bye-bye.